Really, the first step and the easiest step would be negotiations, where the attorneys, or at least the attorney for the business, if they're acting prudently and have either in-house counsel or that they have hired an outside firm to represent them, would be to contact the other party or contact the other party's counsel and see if there's some type of resolution that can be worked out. Now, sometimes if it's based on some type of contractual agreement, then you have to look at the contract and see what in fact the procedure is, and if there are any condition precedents. In other words, if there are any kinds of alternative dispute resolutions that you have to at least attempt before you can file suit. So the first step really would be to try and settle the matter through negotiations. Sometimes those are very brief, sometimes those could take years, but they may very well, in fact, keep both parties out of court, which is preferable. There are also arbitration that the parties can voluntarily enter into. An arbitrator is where a third party listens to the evidence and makes a ruling as if a judge were to make a ruling. And it can be either binding or non-binding, depending on the agreement of the parties. If it's some type of contract, typically it will have language in there that discusses whether or not there will be arbitration. And if it says that the parties must arbitrate, then they can't actually file suit, or at least can't file suit until there's been an arbitration. And the arbitration can be binding or non-binding. So if it's binding, the parties have to live with the decision. If it's non-binding, then the party that loses can file suit. And that arbitration issue may or may not be used as evidence and could be persuasive to the judge, but it's not binding upon the judge or the jury. And then you have mediation. And mediation is where you have a third party that doesn't have decision-making authority, but it helps to have each party listen probably more carefully than they did before, and listen to the downsides of their case and the upside of the other party's case, and to try and bring the parties to a resolution. And if they do, then they sign an agreement, and then that agreement is binding on both parties, so that you can settle the matter that way. One of the advantages to mediation that most people don't realize, or they at least minimize the impact, is that typically speaking, not always, but typically speaking, emotions run high when you're dealing with an issue that is either going to be litigated or is in litigation. So one of the advantages in mediation is that, and good mediators understand this, is they are able to have individual caucuses, which means you can separate the parties. So you could tell a party that the other side has the strength of the case without having to stare at the other party and without name calling and those kinds of things. So a cool-headed mediator may be able to actually obtain a settlement, whereas the other two parties, whether they have counsel or not, could not negotiate that type of settlement.